All right, everyone, panel 3 will be starting right now, and to moderate, we'll be having Mr. Gentis, a clinical lecturer from Yale Law School. Thank you.
Hi, everyone. My name is Jeff Gentis. I have to introduce myself and then the panelists, and you'll be hearing much more from them than me. I am a housing clinician is the reason I'm here. I just want to say I know, especially at a law review event, we have a lot of future judges that will have to appear from here in Connecticut. All of our clients are right, our causes are just. So just make it easier and rule for us in those cases. Second is this is an important part of a symposium. I live nearby in Enfield. It's at least one reason why I'm here is I was able to make it. And then the third thing, this is just possibly my favorite name tag ever. I was also lucky enough to attend the University of Connecticut, and I am a College of Liberal Arts and Sciences, class of '99. So, thank you. In terms of the actual substantive folks you'll hear from today, to my left is Nicole Summers. She's an associate professor at Georgetown. Her research focuses primarily on issues related to housing, including eviction, regulation of substandard conditions, and fair housing law. She also specializes in access to justice, and in 2021-2022 was an American Bar Foundation JPB Foundation Access to Justice Faculty Scholar. She'll be presenting on an empirical study of default judgments in eviction cases in Boston. Second, you'll hear from Professor Julie Gilgoff. She is an associate professor of law at IU, that's Indiana University, Robert H. McKinney School of Law, with a focus on housing law. Her research interests include Fifth Amendment takings jurisprudence, permanently affordable housing models, and legislative initiatives promoting tenant ownership and control, and she'll be speaking about tenant organizing. Third is my colleague, Professor Anika Singh-Lamar. She is a clinical professor of law at Yale Law School, where she teaches clinics that represent affordable housing developers, tenants, homeowners, small businesses, community development, financial institutions, fair housing advocates, and cooperatives. She'll be speaking about the regulation of property management as opposed to ownership, which has gotten a lot of attention recently, and how those regulations currently fail to, but could, better address illegal and uninhabitable housing conditions. And then rounding us up is Professor Rashmi Dayalchand, a professor at Northeastern University School of Law, whose research and teaching focuses on property law, poverty, economic development, and consumer law. And she'll be speaking about the role of banks in increasing access to affordable housing. So first up is Professor Summers.
So first off, thank you so much to all the organizers of this fantastic symposium. It's such a pleasure to be here with you all today and to hear all of the other panels. I've learned so much throughout the day. So my research focuses on eviction. As you may or may not know, about 3.6 million eviction cases are filed across the country every year. That means that eviction cases comprise 22% of all civil cases filed in all federal and district courts, and federal and state courts combined in the United States. So eviction cases are a huge, huge part of our overall civil justice system. Yet we know very little about what is actually happening in these cases, and that's a lot of what my research has tried to uncover. So just as sort of backdrop to what I'm going to be talking about today, there are basically 4 possible dispositions of eviction cases. This doesn't differ too much from what the possible dispositions are in other types of civil cases. So cases can be disposed of through trial, which is extremely, extremely rare, like in other areas of civil law. They can be dismissed altogether, either voluntarily by the landlord or by the court through a motion to dismiss. Voluntary dismissals are somewhat common. Dismissals by the court are pretty rare. And then there are settlements and default judgments. Most of my prior research has focused on settlements. Settlements are extremely, extremely common in eviction court, and a lot of my past research has looked at what the parties are settling for and how those settlements are being reached. But what I'm going to be talking about today are default judgments. And those, depending on, partly what I'm going to be talking about is depending on the jurisdiction, these comprise a huge share of the outcomes of eviction cases. Okay, so why should we care about default judgments in eviction cases? It's basically, I think, three sort of buckets of reasons. The first is the sort of housing reason. So if a tenant defaults in their housing case and a default judgment issues against them, that means they are going to be evicted, they're going to be forced out of their home. And there's abundant research now showing all of the devastating effects of being forced out of your home by a court. It's a pathway to homelessness. It causes all sorts of negative health and educational outcomes for children. There are also procedural justice reasons that we should care. If a case results in a default judgment, that means that there's been no actual adjudication on the merits. The law itself is not being enforced. And then finally, we should care for sort of basic reasons of fairness. There's lots of research, or not lots, but there's some research that's been done showing that the reasons why tenants default, do not appear in their cases, reflects other sort of social and economic injustice factors. So people don't come to court because they have no way of getting there, because they don't have childcare for their kids, because they're sick and physically can't make it to court. And so a default judgment in many instances can reflect these underlying inequalities and has nothing to do with the case itself or the tenant's willingness to participate. Okay, sorry. So we don't know too much about the rates of default judgments sort of across the 50 states because eviction data is really difficult to actually analyze. You can't just sort of go to a housing court and say, hey, give me all of your data, and then quickly figure out what the default judgment rate is. For lots of reasons, that's just not how it works, unfortunately. So the data that we have on eviction default judgment rates, meaning the percentage of all cases that result in a default judgment ultimately, just comes basically from usually locally done studies that have dug into court data on their own and have come up with these rates. And so what you see here is that in many places, and the 4 places highlighted here in red, default judgment rates are pretty high, 40% in LA, Utah, Philly. Interestingly that they were all 40%. These are all independently done studies by totally unaffiliated groups, all have this like exact 40% rate. In those 3 places, Minneapolis, 33%. Then you have Maine and Nova, Northern Virginia, around a quarter of cases. So that's been the sort of cause for concern, and those places have really been the focus of other studies around default judgments in eviction cases. But interestingly, we have these sort of outliers here. In the sort of New England Northeast area, you have Boston, which is what I'm going to be talking about, with a 17% default judgment rate, and New York City with 11%. Now, I think it's all relative. I don't want to say that that's like a great default judgment rate to have. Any level of default judgment rate is probably cause for concern. But relatively speaking, that's a very different reality than something like 40%, where almost half of your cases are being disposed of simply because a tenant doesn't show up to court. So my research, as I said, is focused on Boston, and basically have 2 research questions. And I forgot to say at the very beginning that this is a paper that I'm working on with a co-author at MIT, Justin Steele, who's at the Department of Urban Studies and Planning. So we have 2 questions here. So first, why does Boston have a relatively low default judgment rate? What clues can the Boston data offer about potential reforms that may help lower the default judgment rate elsewhere? So if we want to get that default judgment rate lower, is Boston sort of doing something, or the laws doing something that are getting us to this lower rate? And the second question is, to what extent may variation in the default judgment rates be attributable to variation in the default judgment procedural rules? So are these differences in rates attributable to some extent to differences in the law? Okay, so we have sort of 2 sets of methods here. So the first sort of methodological component of the study is an analysis of eviction court records. And this is part of a broader project that my co-author and I have been working on for many, many years now, looking at this sample of eviction cases filed in the Boston Housing Court. We took a random sample of about 1,000 eviction cases filed over a 5-year period, and then we hand-coded all available information from the case files, actually like went through file by file and coded pretty much everything we could. Learn about the case from those files, and created this massive data set. We coded about, I think, 36 variables, and then we analyzed that coded data. Second, we did a 50-state survey of the default judgment rules. So we looked at the requirements for the tenant to avoid default, the requirements for the landlord to obtain a default judgment upon the tenant defaulting, and then any rules governing removal of the default judgment. Okay, so here's what we found. So in terms of the case data, what we found, interestingly, is that about a quarter of cases in Boston had a default judgment initially. So there was a default judgment entered in the case. But then if you look at what cases ultimately resolved, where the final disposition was a default judgment, that rate was only 17%. That was the number I mentioned earlier. So what that meant is that about a third of default judgments were removed, which is sort of an interesting finding. That's not sort of what we tend to talk about when we talk about default judgments. We tend to just talk about people not showing up to court and that being the end of their case. We're finding that there was this higher rate of default judgments, but then that was undone somehow. So that led us to the question of, well, how? How did that happen? And what we found from our data is that in about half of those cases with removals, the tenant had filed a motion to remove default, which is what you as lawyers might, or law students might think happened. But in about half of them, the landlord just agreed to remove the default through some informal process. The tenant never actually filed any sort of motion. The landlord just agreed to undo it. We found that tenants filed a motion to remove default after about a quarter, 23% of default judgments. So there were actually, to sort of put the data together, there were actually a lot of there were more motions to remove filed that were decided negatively, had those all been, in fact, had all those in fact resulted in the default judgment being removed, we would see an even lower rate of default judgment. So we found that 37% of those motions to remove settled, 29% were denied because the tenant didn't appear. So the tenant has to file the motion to remove, and then they're given another court date on which they have to come back and actually argue that or try to settle it with the landlord or their attorney. 24% were denied by the judge after hearing, and 6% were allowed by the judge after hearing. So judges overwhelmingly actually were denying the motions that came before them, but yet a significant portion were resulting in removal. We also looked and actually analyzed those motions to remove to sort of glean or try to get a little bit of insight into what was the reason behind the initial default. What we found was that the most common reason stated for the default in the motions was that tenants did not have notice of the initial hearing. 18% cited a medical issue. 12% said they were late to court. So in Boston, there's a very strict time by which you have to be in court when your case is called. If you're not there for the call of the list, you're immediately defaulted. So some people were there but just missed that call. 8% said lack of childcare. 6% had already paid up the rent they owed and thought they didn't have to come to court. And then a small 2% had transportation issues. So let's move on to our 50-state survey. So sort of the process that I've laid out so far is sort of a case filing, tenant defaults, the court issues a default judgment, and then potentially there's a removal of the default judgment. And so that leads to sort of 3 sets of rules. So for the default, the sort of relevant rule would be what must a tenant do to avoid default. For default judgment, it's upon default, what must the landlord do to obtain a default judgment. And then for removal, when can a default judgment be removed? So there's sort of 3 sets of rules that are going to be applicable to this process. So what we've found is that, so looking at what must a tenant do to avoid default, there's sort of 2 options here. States can either require that the tenant just has to show up to court on the date that their case is scheduled, so they just have to appear. Those are all the states that are colored in green on this map. That's most states. That's green. Throughout, I'm going to use green as being pro-tenant or better for the tenant. The states that are coded in red are states where the tenant actually has to file an answer prior to their first court date. So they have to somehow figure out, oftentimes the court summons will say, you have to file an answer in this amount of time or by this date. If you don't do so, you will be defaulted. Tenants have to understand what that means, what to do, where to file it, to serve it usually. That's a lot more onerous for your typical tenant-facing eviction. So those are the states colored in red here. And then the states that are colored in yellow are the ones that have a mix of where those two rules vary by county or at some sort of local level. So then, upon default, what must a landlord do to obtain a default judgment? And so for those proceduralists among us who know that typical default judgment rules require more than just default of the party to get a default judgment. The plaintiff will have to actually show something to get a judgment from the court. So the states that are coded in red don't require the landlord to do anything beyond file the initial pleadings. Basically, once a tenant has defaulted, if they don't appear in whatever form they're required to, the landlord is just going to get a default judgment. They get it automatically as a matter of course. The states coded in yellow are ones where the landlord has to, in addition to having filed the initial pleadings, show some sort of proof of service or compliance with the Civil Service Relief Act. So basically just that they serve the tenant, and that's enough to get a default judgment. And then the states coded in green are ones where there's some sort of additional documentation or proof of the underlying merits of the claim that's required in order to get a default judgment. So you can see here that there's a lot more sort of variation among these three options. And then finally, when can a default judgment be removed? So there's a surprising number of states, all the states coded in red, where the default judgment can never be removed. The rules literally just say this is a final judgment that is unremovable, essentially, unless you appeal it, unless you go through with a full-fledged appeal. So those are the red states. Orange states are states that have a higher standard than what's in Rules 55 and 60B. So 55 and 60B are the sort of general civil procedure rules governing default judgment, removal of a default judgment that allow removal for a wide variety of reasons: mistake, inadvertence, neglect, other good cause. They're fairly liberal. And so orange states require more than that in eviction cases specifically. Yellow states are ones that just apply the general civil procedure rules to eviction cases. And then the few states that are coded in green here are the ones that have a more liberal standard than what's in Rules 55 and 60B. So really basically try to encourage removal to happen in eviction cases specifically. So there are specific eviction rules. Okay, so what do we take from all of this? So first, eviction default judgments should be of serious concern to housing and access to justice policymakers for all the reasons I mentioned. Second, the Boston data suggests that its relatively lower default judgment rate may result from it being an appearance-only jurisdiction, so one where the tenant just has to show up to court on the date that their case is called. They don't have to do anything prior to that. And them just having a higher rate of default judgment removal. There are three types of default judgment rules that may affect the jurisdiction's default judgment rate, which are tenant requirements to avoid default, landlord requirements to obtain judgment, and the standard for removal of default judgment. And there's significant variation in these rules across the 50 states and DC. And finally, we need more rigorous research on eviction default judgment rates, including comparative and causal research that can really get to the ultimate question of the extent to which these rules are really mattering for which cases are resolving in default judgment and which are not. So thank you.
Next is Professor Gilgoff.
Thank you, everybody. Thank you to the organizers for today's event. It's so lovely to visit your campus. My name is Professor Julie Gilgoff. I'm from Indiana University, Robert H. McKinney School of Law in Indianapolis, and I'll be talking about tenant organizing. There's been a recent resurgence of tenant organizing around the country, including in Connecticut. As many of you know, there's a statewide Connecticut Tenants Union with 17 local chapters. And the Blake Street Tenants Union recently collectively bargained their lease with their landlord, Ocean Management, after severe neglect of living conditions. When Ocean Management, who owns hundreds of buildings, took over, there was a mouse infestation, heating issues, electricity problems, and tenants went a year and a half without hearing from their landlord, When they did eventually hear from Ocean Management, they were told that their rents were increasing by 30 to 40%. And so the Blake Street Tenants Union formed at that time and collectively bargained with the landlords, during which time 16 union members were served with eviction notices. And the union protested outside of City Hall, garnering the support of elected officials and alleging retaliation, which it was. And so they won their collectively bargained lease with just cause eviction protections embedded within the lease. As the union continues to fight for just cause eviction protection statewide, at least it is guaranteed within these properties. And so we're seeing wins like this around the country, including in unlikely pockets of the country, in conservative jurisdictions, Kansas City, Missouri, Louisville, Kentucky. I live in Indianapolis, Indiana, where there are some of the highest eviction rates in the country, but what's new is tenants rising up to say that the status quo is not good enough. When we talk about the housing crisis, low-income communities have been in crisis for as long as our country existed, yet we ask, who is this a crisis for? It's a crisis for them from their perspective, but not for the people who are profiting from the system. So corporate landlords, landlords who receive a federally backed mortgage from Fannie Mae, Freddie Mac, receive very low interest rates, and at this point there's no strings attached with the rights that are attached to receiving those favorable federally backed mortgages. And so it's currently a strategy among tenant unions around the country to target buildings that receive these favorable mortgages and to draw attention to the uninhabitable living conditions. Brendan Balau's book Plunder recently drew attention to the harm of private equity firms like Blackstone and the Carlyle Group buying up distressed properties, as well as manufactured home parks, retailers, nursing home chains. Their business model is to raise rents, disinvest from basic maintenance, and shift services that used to be covered by the landlord to be covered by tenants instead. And even during times of economic recessions, produce high yields for their shareholders. So this is a very intentional business model. And in the aftermath of the pandemic, we've seen a rise in small and medium landlords offloading their distressed properties onto corporate entities. So this is a real shift of who owns rentals around the country and noticing the patterns in higher eviction rates, spikes in rents, and disinvestment from building conditions even further as a result of these trends. And so very recently on August 8th, over the summer, the Federal Tenant Union Federation has launched, and this is a union of unions. Their motto is, every tenant deserves a union. And they're serving as a voice and coordinating efforts nationwide. And so their current target is, again, these buildings that received a federally backed mortgage. The tenant union leader, Tara Raghavir, is based in Kansas City, and they're launching a rent strike at the level that we have not seen again in our country for many years. They've targeted 2 buildings, that one of which is already under receivership for negligent management. And the building, Quality Hills, has received media attention for, in March, there was no hot water for 2 weeks. The AC was out the entire summer. And recently, in July, a 3-year-old fell out of the window and died. His parents had been requesting new windows and complaining to management for months without receiving any response. And so organizers such as Janae Manley says, we're organizing like our lives depend on it because it actually does. And the first of every month, they say, is a time when tenants pay a disproportionate amount of their rent to their landlords. The first of the month also marks a new organizing opportunity, And so beginning November 1st next month, they're going to be joined by tenants not just in Kansas City, but in other jurisdictions nationwide. Their hope is to draw attention to these uninhabitable living conditions, especially in these buildings that receive federally backed mortgages, and to say that these federal subsidies should come with strings attached. And they have a long list of requests, including just cause eviction protections, annual rent caps, guaranteed lease renewals, anti-retaliation protections for the right to organize. So they are asking, and they're not asking nicely any longer. They met for 2 years with federal regulators who came to visit their buildings, toured these living conditions, and at the end of 2 years, tenants were told that the federal regulators were still in listening mode. They're gathering more information. A tenant said that's not good enough, and that's when they decided to go on strike. And so you'll see more of these strikes popping up and coordinated by the Federal Tenant Union Federation. That's their acronym is TOUGH. These are some images from the rent strikes that are currently going on. It was launched on October 1st. And so tenants are being served with late notices, late fees for their rents, even though they're urged by officials against retaliation. And tenants are fierce. They're burning the notices, holding public campaigns and protests. And those are some images of their of bathrooms and the conditions in the building. So some scholars are noticing, drawing comparisons with the 1930s when the National Labor Relations Act was passed, which is a federal statute protecting workers' right to organize, whereas tenants do not have any federal or statutory protection to organize, workers do. And so some scholars, including myself, are drawing comparisons between labor law and tenant organizing, and seeing where tenants can borrow from the strengths of labor law, while also noticing what particular needs tenants have different from workers. And so this is a slide. Hopefully you can see it better than I can, but labor law has much to offer tenants in the form of payroll deductions, automatic fees deductions. How are tenant organizations or tenant unions going to be funded? Labor law has those models to borrow from. In many jurisdictions, when an organizer enters the property or the home of tenants in order to help organize, they can be arrested for criminal trespassing. So some of these protections are guaranteeing organizers the right to enter. In some local jurisdictions, they have to be accompanied by a tenant as a guest. And then the landlord agrees that they can use common areas in order to organize. Even central communication, getting contact lists of workers have been systematized in a way that doesn't exist for tenant organizing, where organizers have to knock door to door and are oftentimes met with hostility. There's no way to communicate or know who lives within a given property without this sort of support and acceptance that exists in some local jurisdictions, but in most do not. And so it's important to guarantee in this federal statute, which I argue should guarantee a base level of protections, which states can augment but not diminish. The whole basis of the National Labor Relations Act is a collective bargaining model where workers negotiate with their employers for the terms and conditions of their employment. And so thinking about should tenants have to bargain for certain protections like just cause eviction protections, rent caps, or should it be guaranteed? So also in my forthcoming article, I look at the Fair Labor Standards Act as another model of labor law that might be useful when modeling a tenant organizing statute. And FLISA guarantees minimum wage and overtime protections, not, of course, at the level that it should, but individual states and jurisdictions can augment the minimum wage, but they can't go below a certain point. And this might be helpful in envisioning these statutory protections. So some recommendations, in my mind, is very linked between tenant organizing and social housing, which is removing land from the market altogether. How much can you convince private equity firms that they shouldn't cut corners in order to create high yield profits for their shareholders within a short amount of time, which is their business model? So many tenants are trying to remove the landlord altogether from the equation, collectively purchasing a property with the help of outside financing, such as community land trusts or other systems of financing which might be available to tenants in collective ownership models like limited equity cooperatives. So social housing can come in many forms. These are some of its principles: permanent affordability through decommodification. So these are rent caps that never go away. Comparing it to our country's method of building affordable housing, which is primarily incentivizing private developers to create a limited number of set-asides within any given building, typically 10 to 19%. And its affordability terms tend to expire between 30 and 55 years, depending on the state. But under LIHTC, these developers are heavily subsidized and for exchange for creating that limited number of units, as compared to social housing models in Vienna, Austria, for example, where any new development has to contain 2/3 affordable units in order to get any form of government tax abatements. And in Vienna, Austria, which is one of the best known models of social housing, over half of all housing is social housing, as compared to our association with public housing as being somewhat stigmatized. Social housing is mixed income housing, where higher income tenants subsidize the rents of lower income tenants, and its locations are not in segregated neighborhoods, but rather in transit accessible neighborhoods. So certain states, for example, California just passed a statewide social housing bill where they're looking into adopting social housing on a much greater scale than is currently known in our country. Where social housing does exist, but on a smaller scale, where tenants do band together, purchase a home, but are not guaranteed the right of first refusal. So opportunity to purchase policies have been popping up around our country. The best known is in Washington, D.C.'s Tenant Opportunity to Purchase Act, or TOPA, which has been which was passed in 1980 and has given rise to tens of thousands of limited equity cooperatives as a result. When a property goes up for sale, when an owner chooses to put up a property for sale, tenants get the right of first refusal. And so if a tenant organization exists, the tenant organization is allowed to put in a bid. They typically offer a market rate bid, and the district housing trust fund supports tenants in doing so. In some instances, assigning the right to a community group like a community land trust who has greater leverage, can use their existing portfolio as collateral to help them acquire funding, and in some instances then transfers the property back to the tenants once they're able to refinance or afford the property themselves. There's a variation on TOPA, which is known as COPA, Community Opportunity to Purchase Act, and instead of tenants getting the right of first refusal, community groups do. And then, as I said, as long as they pledge to hold the housing as permanently affordable for the sake of the tenants. And oftentimes there's restrictions on the area median income of tenants that they need to provide housing for if they acquire funding from the city or state for that purpose. And opportunity to purchase policies are more widespread in manufactured housing communities, and where there are well-known opportunity to purchase policies, which haven't been receiving as much pushback as the TOPA policies that have been introduced in jurisdictions including New York, Massachusetts, California and in many different cities, and no other TOPA policies have been passed because of the pushback that developers are giving, not wanting to infringe on their property rights. Just showing the importance of manufactured home parks, where the typical price is much lower than conventional home ownership, but manufactured homeowners are simultaneously homeowners as well as renters. They may own the home that they live in, but unless they own the park where their homes are parked, they can be evicted, and unlike conventional renters, their homes are then stuck. Oftentimes, once you affix it to the ground, they can't just pick it up and move it to another park, especially when the parks are not available. So just really emphasizing the importance of passing these opportunity to purchase policies so that these manufactured homeowners have more control. So I will quickly move through this. Financing, of course, tenant opportunity to purchase policies, tenants are only able to afford to remove the land from the market if they have outside financing, and I will leave that to my colleague to discuss in her subsequent talk. Thank you.
Next up is Professor Singh Lamar.
So when you go this late in the day, in order to keep everyone's attention, you kind of got to pick a fight. So I'm going to pick at least one. We just heard from Professor Gilgoff about some of the rising concerns about large-scale corporate ownership of housing, and in fact, it's true that lawmakers across the country at every piece of government have been focused on this. There have been congressional hearings about private equity in housing. There's been local governmental attempts, including here in Hartford, to get at who owns rental housing. Something called the End Hedge Fund Control of American Homes Act was introduced in the Senate last year. And I'm going to tell you today that I don't think it matters. Jeff and I, Professor Gentis and I, spend a good amount of our time suing slumlords, and I'll tell you they come in all flavors and sizes. So we sue owner-occupants, we sue big out-of-state companies, we sue resident-controlled communities. They're all equally capable of sucking at landlording. And I think fixing that is a little bit harder than simply getting fixated on who it is who owns the property. So I'm here today to tell you to pay attention to management. Who manages property? What does management even mean? Because a lot of the harms that you've heard about that tenants suffer are acts and functions of management. Failure to maintain, failure to make necessary capital expenditures, escalating rents, retaliatory or otherwise illegal evictions, sexual harassment in housing. Management's a harder nut to crack, but it's the only one, I'm gonna argue, just because it's late in the day and I gotta pick a fight, it's the only one worth eating. Sorry, extending bad metaphor. Okay, so corporate ownership of housing has been blamed for a bunch of things, and I'm just gonna rattle them off. One is making homeownership more difficult to attain. Another is they blamed for increasing rents. They've been blamed for being worse at maintenance. They've been blamed for evicting tenants faster or differently than other landlords evict tenants, that they're quicker to evict. There is empirical data on a small amount of this. So there are some studies that do suggest that large-scale corporate landlords are quicker to evict, that their processes are more automated. So as soon as you miss a payment, their attorney gets called, the paperwork gets filed, et cetera. But none of these other things for which they've been blamed actually have a ton of empirical support. And one thing I love about Professor Oliveri's paper is an effort to kind of get at the ways in which different kinds of landlords might be guilty of different kinds of things, because there isn't actually a lot of data to support that, although you can develop theoretical models for whatever you want. Meanwhile, regulating the kind of ownership of housing does have knock-on effects, right? So the thing that we care about are like rents and eviction rates and maintenance, and then somehow we get from there to then regulating ownership. Like, that's pretty indirect and tenuous, but regulating ownership does have direct effects that can be quite nefarious. So There are some places around the country in state law and local law that have attempted to regulate ownership, either by, most frequently by requiring owner occupancy, right? The flip side of regulating ownership in that way is you can make landlording harder to do, but then you also make renting harder to do. So the statutes that tend to try to make landlording illegal simultaneously make renting illegal, and that's bad for renters. So, what to do? This seems hard. What do you do? Other than what I normally talk about, which is building 3 million new units, as one of our presidential candidates has said. There's huge supply issues, but I'm not going to talk today about supply. I'm going to try to focus on some of the more fine-grained things you could do to focus on housing quality. And I will say that while we are in a relatively wealthy blue state, this is a live issue. At least 3 people have died in the state of Connecticut in the past week in fires, okay? So there are, broadly speaking, 2 kinds of codes that regulate housing quality. Building codes, which govern like what you build at the outset, like at the beginning. And those exist everywhere. In Connecticut, we've got a state building code. But then there are also housing codes, and not everywhere has a housing code. But a housing code typically regulates maintenance. So recognizing that quality isn't just about what's built, it's also about how it's taken care of over time. I'm particularly interested in housing code enforcement intended to address tenant health and safety, rather than housing code enforcement intended to address vacancy and blight, which I think are sort of different kinds of issues. Almost all of our clients live in houses that don't comply with the housing code, and as I mentioned earlier, their landlords are like run the gamut, right? We've had stories in New Haven, which is where I practice, of tenants complaining about I didn't know who to call because there was terrible conditions and whatever, and then lo and behold, it turns out they live in a resident-controlled co-op, okay? Slumlords come in all flavors, okay? So I sometimes teach an interdisciplinary clinic with folks at the architecture school, and one of my co-teachers at the architecture school does a lecture on building codes. So remember I told you building codes, housing codes. He gives a lecture on building codes, and he'll give his lecture, and then at the end he'll turn to the room and he'll say, mostly to the architects, he'll say, who's responsible for enforcing building codes? And they'll say, oh, code enforcement, the health department, consumer affairs, the AG, I mean, they'll rattle off a bunch of regulators. And then I've seen him do this like 2 or 3 times, so I know it's coming at the end. He gets, they don't say the thing he wants them to say, and he finally says, you're architects, you're responsible for enforcing the building code. And in fact, like architects, licensed architects stamp the drawings, they take them to the building official, and they say, here, like, I promise that this building complies with the building code. Well, you can ask the same question about housing codes. Like, who's responsible for enforcing housing codes? In Connecticut, and in a lot of places, we see that nobody really thinks it's their job, right? We can talk about what it takes for a tenant to try to get a court or a local code enforcement official to care that the code's not being followed. But on the ground, like in practicality, in real life, who enforces the housing code? The property manager, right? Like that's the idea, is that you've got a person whose job it is to enforce the housing code, but we do not, in this country, regulate property management. It's like not a thing that we do. So you might say to me, Anika, I'm here in the city of Hartford. We have a landlord licensing scheme. No, you don't. You have a unit licensing scheme where a landlord has to submit a piece of paper that says, please license my unit, and then maybe the city comes out to inspect the unit, or not. Maybe they just search they don't have to. The ordinance says may. Or they just search their records and they're like, oh, we don't have a report of a problem, so we're going to issue the license. And you might say, well, that's Hartford. This is a tiny little city. They just don't know what to do. No, nobody does this, right? So Philadelphia, Detroit, all of the larger cities that purport to have a landlord licensing scheme have no such thing, right? At most, they have a situation where you search their records and then you see if there's been any code enforcement activity, and then you imply from the lack of code enforcement activity that everything is peachy. So I'm going to propose basically like a two-pronged thing here. And if I have time, I'll maybe tell some stories about bad code enforcement situations. So one is like, why not license property managers? Nobody licenses property managers. So there are places that purport, there are like states that purport to license property managers, but when they do, the test that, I've looked at some of these exams, the test that you have to take to get licensed as a property manager, you have to demonstrate that you know that you're not supposed to discriminate against people in the leasing process. And you have to demonstrate that you know that when you collect rents from tenants, you have to turn them over to the landlord, okay? Those are the two things. You do not have to demonstrate that you know how to deal with a vermin infestation, that gas heating appliances should not be in closets, how to remediate mold, what dehumidifiers do. I'm just rattling things, yeah, okay. Rattling things off from our own work. That's not what those tests test for, right? So, what is a licensure requirement? It's just the idea that you've got to prove that you know how to do a thing, right? So your hairdresser is licensed, probably. At least they're supposed to be. Your car mechanic, right? But your property manager, not so much. So the fact that your property manager could kill you doesn't rise to the level of requiring them to actually be licensed. And I've talked about those places where they do have licensing schemes, what they're actually testing for. So, an actual, and I'm not suggesting that landlords actually have to be licensed because I don't care who owns your building. I still don't care about that. What I care about is that your landlord has identified a person who does know what to do when there's a rodent infestation to come in and deal with it. So, what would a properly structured licensing scheme look like for property management? Yeah, you'd have to demonstrate you know not to discriminate against people, but also you'd have to demonstrate that you know how to deal with basic like housing maintenance and code issues. The flip side of this is that if you don't have a property manager as a landlord, or your property manager has failed, and I will say like a benefit of this scheme is that the current schemes that exist to do landlord licensing have no way of tracing violations across corporate ownership, right? So you can lose your license for a particular unit and maintain it for the other 95 units you own around town. If as a property manager you lose your license, well now the landlord's got to go out and hire a different property manager to manage those 100 units. So the thing that you screwed up is actually traceable to everything else that's going on. The flip side of this is that we've got to use receivership a lot more than we currently do. There are some states around the country that use receivership more than they do. But the idea ought to be that if you don't have a property manager, or your property manager has lost their license and you have not identified a new property manager, that we are quicker to impose receivers on buildings where we know that there are problems. One of those fires that killed somebody in Connecticut in the last week was in a building where the city of New Haven knows that the guy has like 20 other buildings. And there's literally nothing they can do right now, right? Like they can work towards a point where they can do something, but right now, days after somebody died, there's nothing they can do. So putting into place a system where you can do a thing, I think is immediately, because your property manager lost their license, right? I think is important. And I'll be gonna regret it because I probably forgot to say 17 things, but I'm gonna leave it at that. Thanks.
And then we have Professor Dialchand.
Thank you. So I chose to go last. I volunteered to go last. And here I am. I want to start by just thanking so much the organizers of this symposium, which has just been so informative and just so deeply, I think, I wouldn't say satisfying because it's also been painful in meaningful respects, but also just such an important moment of thinking and gathering. So thank you all so much and for including me as well. So I'm Rashmi Dialchand. I'm going last, and so I'm going to try to address this, not necessarily by picking fights with anybody, although you may see what I'm about to say as rather feisty, possibly, or actually possibly completely not feisty. But I'm going to address this by telling you, in case you want to take a nap for the next 15 minutes, what my bottom line thesis is. And I'm going to start by saying I'm pretty much switching gears from what a lot of the conference has been about. So we've talked about the very important set of issues relating to access to housing, especially, I think, mostly in the context of rental housing, which is crucial. I'm really going to try to approach the question of housing accessibility from the perspective of home ownership and housing as a wealth-building proposition. So it is a bit of a switching of gears. And so I want to say, I think, 4 things. First, what I want to really put on the table is a second or third best interim pragmatic proposal. I'm not really proposing to change the world. I'm not proposing a revolution here, although ultimately that is what I'd like. What I'm focusing on is the big banks. So here are the 3 main points that I'd like to make. First, as much as we may, in meaningful respects as a society, or at least as progressive members of society, have given up or had the instinct to give up on the potential for big banks to be part of the solution for housing accessibility, I'm going to argue that they have to be. And they have to be part of the solution by addressing the gap in finance, right, in financing housing. So they are really the horsepower behind the financial system, right? We've got CDFI banks, they're being increasingly financed, they're doing amazing things, but the big banks, the mega banks, the ones that, are in the news, are the most powerful part of the financial system, and to work around them, to find ways in which to address access to financing for housing in ways other than to engage the big banks is really a lost opportunity. Secondly, that regulatory intervention will be necessary to ensure that big banks do their part. And thirdly, that I keep hesitating about this, but I'm going to say it. What we need regulations to do is to push big banks to go small in mortgage lending. In other words, to push big banks to work to universalize access to safe financing for home ownership. Now, a bunch of, I think, absolutely necessary assumptions and caveats. First of all, I'm assuming that home ownership will, for the foreseeable future, like it or not, fraught though it is, continue to be a powerful means of wealth building, and especially, perhaps, including for Black and brown families. Okay. Secondly, my normative position actually aligns, perhaps word for word, with many of the things that Abby Atkinson, among others, but perhaps most of all Abby Atkinson, has written, in saying that debt in general is an unfair and bad thing, right? It's not really, even though we are effectively, de facto, treating it as a means of accessing wealth building, almost as a form of wealth, it's not a fair or appropriate way to build wealth. And then, almost finally, therefore, what I propose here, to the extent that I'm making a proposal, cannot therefore be the only solution. We need ways to generate wealth by means of stabilizing income, by means of really reincorporating savings into the average American's financial pie, by means of increasing access to retirement planning and building, and many other things. But housing costs continue to rise, both for rental, as we've seen, as well as for purchase, and that's what contributes to statistics like these. So, I only have a few slides, but hopefully they just, remind you of some of the key points. In 2015, as perhaps many of you know, the Federal Reserve Bank of Boston produced a study called The Color of Wealth in Boston, which was breathtaking because of statistics like this, that while white households about a decade ago had a median wealth of $250,000 almost dollars, Black households in the Boston area had a wealth of $8. The Color of Wealth study by the Fed Bank of Boston was really the source of a lot of additional measuring and studying, and distressingly, though not surprisingly, the wealth gap identified in Massachusetts and in Boston has been identified in many other places as well. So as you see, white New Yorkers, as of just this past year, had a median household net worth 15 times greater than black New Yorkers. And then the second statistic is for the United States as a whole, the median white wealth household net worth, $291,250. The median black household net worth, around $30,000. Wealth gap in Chicago, $210,000 for white families, zero on average for black families. And home ownership rates in meaningful respects mirror that kind of wealth gap. So in Chicago, in 2019, 72% of white households owned homes, compared to 48% of Latino and 42% of black households. This report that produced that statistic was co-developed by the Chicago Community Trust, which is a nonprofit organization, in partnership with a number of other organizations in Chicago. I think it was partially financed by Chase, and also concluded that this is mainly because black and Latino buyers have historically been excluded from traditional credit markets. Lack of access combined with rising housing prices and the low supply of affordable housing has locked an untold number of buyers out of the home ownership market. Here are the rates in Boston. You can see at the far right of the bar graph, 73% of white families own homes in Boston. 40% of black families, 37% of Latino. And this is the crux. This is really what I want to focus on for much of the remainder of my presentation. So the biggest culprits in terms of financing access to home ownership are the biggest banks. So a study by a nonprofit organization and a local news organization in Chicago produced these stunning conclusions, these stunning findings, that Chase had two branches, this was as of about 4 or 5 years ago, in Chatham, which is a majority black neighborhood in Chicago, that held a total of $80 million in deposits, but from 2012 through 2018, the bank made 3 loans per year in the historically middle-class black neighborhood. In 2017, Chase made a high-profile pledge to invest $40 million over 3 years in Chicago to promote economic opportunity in the city's south and west sides. But if it had just loaned in those black communities what it loaned in majority white neighborhoods for that same period, that would have meant an additional $829 million each year for Chicago's black neighborhoods. Even if Chase had simply made loans in black neighborhoods at the same disparate rate as the overall market, that would have meant an additional $80 million every year, as distinguished from the $40 million for 5 years that it pledged. In other words, it loaned 2.4 cents in majority black neighborhoods for every dollar that it loaned in majority white neighborhoods. And in case you're thinking that either the study or I are picking on Chase, Bank of America lent 29 times more in white communities than it did in black communities, and 21 times more in white communities than in Latino. Wells Fargo lent 10 times more, and so on and so on. And then there's the issue of bank closings, which is a key part of the story, right? So we know banks are merging, we know they're closing branches, we know there's a move towards digital financing. What's the impact? Well, one way to measure this is the rate at which bank branches are being closed in majority black communities versus majority white communities. And you see that it's at a rate of 14.6% in majority black communities, whereas it's 9.7% in all other communities. And again, Chase and other banks, other mega banks, similarly sized, are the worst culprits here, as you see in the second statistic. Oops. So now, I just want to go back and leave this up on the table, on the slide, as I continue. So why then am I saying big banks have to be a part of the picture? Well, obviously the statistics are terrible, but big banks have been very good at avoiding their responsibility. The issues are partly that even as CDFI banks have been increasingly capitalized, for example, billions of dollars from the Emergency Capital Investment Program, and even though they are developing excellent risk-reducing ways in which to lend, certainly in black and brown communities, but also in lower income communities, they just don't have enough resources to meet the incredibly high need. And nor can, initiatives as innovative as they may be, such as postal banking, and even, I would say at this point, public banking, even though there does seem to be significant potential. Meanwhile, all of these big banks, each of them has, foundations that have received a lot of press, especially in the wake of George Floyd's murder, for funneling money for community development. But the point here is they're doing it as acts of charity. There is actually no regulation requiring them to do any of this, and they're not using their expertise as banks, right? They're leaving that work of lending to others. So what is to be done, and this is the part where I may be picking a fight, the answer, I think, is to move towards a goal of universalizing access to mortgage loans. And that means that big banks have to do their part, and what they need to do, again, is to go small, to originate small mortgage loans in greater numbers in majority black and brown and middle class and lower income neighborhoods. Nobody else, I would argue, has, at least at this point, the systemic power and efficiency to universalize access in such a way. Now, I could just end there and leave it as a rallying cry, and I actually do think that part of the point that I'm trying to make is, and I'll be done in 5 minutes. Part of the point that I'm trying to make is that right now, to a meaningful extent, the possibility of activism vis-a-vis big banks doesn't seem very real, right? So it is a rallying cry to the extent that I'm saying we need to make this an issue. We need to get mad about it and talk about it. But I also want to take a step back and talk about regulation here. Because what I want to argue, what I want to say, is that the reason big banks are not doing this already is not just as a regulatory matter because of race and other forms of discrimination, though obviously that, and not about risk, which is what they are claiming, but rather about profit. From a business perspective, therefore, solving the problem, forcing big banks to do what they need to do, is not about managing risk or helping them or regulating in such a way as to manage risk, but rather about addressing profitability. And you know what? It's going to be less profitable to force them to go small than allowing them to engage in the activities that they have been engaging in up until now, which are actually pretty darn high risk, but also incredibly high profit, right? So that's why I'm saying that the solution here is not about helping banks come up with their own business solutions, because they won't. It's about regulating them. And in particular, regulating away from supporting their single-minded pursuit of profit. So currently, banks are regulated in such a way as to provide enormous protections, as I think most of you know, and indeed subsidies for the work that they do. And ironically, historically, these regulations are in the name of limiting systemic risk, which we all certainly want to limit, and on the assumption that banks will provide financial access to the public widely. These regulations are by no means limitation, in fact, there have been deregulations in this regard, on the pursuit of profit. And therefore, they provide very minimal requirements for banks to universalize the availability of credit for things like home buying. In other words, even with the new Community Reinvestment Act, if it ever is implemented right now, the American Bankers Association has filed a lawsuit against its implementation. But even with the new Community Reinvestment Act, which I won't have time to talk about, there's a big mismatch between regulatory protections for the mega banks and the very limited services they provide to black, brown, and lower income communities in general, and also in pursuit of home ownership. Meanwhile, as I have described very briefly, CDFI banks have, and other players in the market, have essentially proven that it is very safe to expand the market for credit to many more black, brown, and lower income borrowers. Remember, the big banks are not refusing to lend because of concern about risk, or at least That's, even if they're saying that, it cannot really be a tenable argument at this point. And in other words, we are still in a system of not only de facto financial segregation, but actually also, in light of the enormous regulatory protections for the big banks, de jure financial segregation as well. So, do I even have any minutes left? 1 minute? I'll take it. So here are some thoughts about regulatory reforms to help us get there. Okay, the big point is, again, reallocating regulatory protections and subsidies. So why are we continuing to subsidize big banks if they are not providing financial services to giant swaths of Americans? Regulators, I would argue, need to reallocate privileges like FDIC insurance to create, at least for now, incentives and ultimately, ideally, also mandates for big banks to lend safely to many, many more people. Secondly, transparency. It's a foundation, it's just a foundation, but for example, an agency like the Consumer Financial Protection Bureau, which has proven both its ability as well as its real motivation to identify and dismantle racist practices and impacts, should be, I think, tasked with enforcing not just the Home Mortgage Disclosure Act, but also additional regulations that force banks to provide information about, for example, declining trends in home mortgage lending in specific branches and subsidiaries across their lending areas. And then finally, at the very least, regulatory incentives should be provided for big banks to do a lot more partnering as a mandate with banks like CDFI banks and other players, perhaps for Community Reinvestment Act credit, or perhaps just because they are required to do so, to provide capital so that the experts within those banks can use their expertise to lend to in smaller dollar amounts to a wider range of borrowers. So I want to end where I started, which is that this can't be the only solution. We need to look again more broadly at ways in which to stabilize income and provide access to financing, but at least as a start in the interim, we have to go for the big banks. Thank you.
So I'm just going to start with 2 questions, and then we'll open it up to the audience. The first one's parochial but important. Anika, for the property management licensing scheme that you suggested, will you provide for some type of insurance or bonding requirements so that when we sue them, we'll have something to recover against?
Yeah, so Jeff and I share an obsession with treating tenants like consumers, which is to say protecting tenants the way consumers are protected. And I have to cite in Eric Sirota, who's at the Shriver Center, who has a great article that I would recommend to anybody who's interested in this topic. And yeah, I mean, I think once, and it's in the draft, so you'll have to read the symposium. I'm going to make a plug. You have to read the symposium issue of the Law Review in order to hear more about this. But once you really begin to brainstorm and pivot around the idea that tenants are consumers, you open up like a whole range of regulatory tools that you haven't previously considered, right? So instead of thinking of the property like strictly in rem, that what we care about is this unit, but instead you're like, this consumer has got to be protected, then licensing is one kind of consumer protection, but bonding requirements. So I can't get my kitchen remodeled without hiring a home improvement contractor who's got a bond with the state of Connecticut so that if they then scam me, I have something to look to. But I can rent an apartment where, goodness forbid, like you could die in a fire or inhale carbon monoxide is one of my stories that I didn't tell, without any kind of that kind of protection. So yes, I think if you have a licensure scheme, then you can also implicate insurance schemes and bonding schemes as well. And that might sound expensive, right? So I mean, there's serious counter arguments around this kind of regulation, but we're talking about a very large risk pool, right? So it's not that it's costless, but I think the costs are minor.
Okay. And then my second question is just, and it's really for anybody, I think Berkeley does a good job of bringing together practitioners and scholarship in the area of consumer law. And I'm just wondering, if folks have ideas about ways to make that more happen more in the housing context. I mean, this is a nice start, but this is a nice event, and it's not a start. But curious about ways to make it work, because it's important that we talk to each other.
Well, I can say I know some states, including Massachusetts, where I practice the most, allow consumer protection laws to be used as a defense and counterclaim in eviction cases, and that's a really powerful tool for tenants because it allows basically if you're a tenant who has bad conditions, if the property, it applies to properties with, I believe it's 2 or more rental units, or maybe 3 or more rental units, but anyway, it's designed against, to protect tenants in properties of larger or more professionalized landlords. So if you have bad conditions, if you're a tenant in one of those properties, you can sue not only under warranty of habitability, but also as a violation of the Consumer Protection Act, which allows you to also seek attorney's fees, seek treble damages. It's extremely powerful when used well. So I don't know how many states have that, but at least I can say Massachusetts, it's a great tool.
Cool. Any questions? Yeah. Sure.
All right, so this question, that's loud. Specifically for Professor Dialshan, I really like your idea of using homeownership as a tool in order to generate wealth for historically disadvantaged communities. That said, how would forcing large financial institutions like big banks to indiscriminately increase loans without regards to creditworthiness or risk differ from the housing bubble of 2008?
Yeah, no, this is a piece that I literally forgot to say at the very end of my talk because I was so worried about time. One of the regulatory imperatives has to be fair, safe lending requirements. So when I talk about regulation, really that has to be part of the regulatory package. I'm so glad you raised it. We cannot replicate the subprime crisis. We can't replicate the loss of wealth as a result of predatory lending. I'm actually writing a book about this whole thing, the conundrum of banking. And what I would say is making big banks do it right is going to be so much safer than the moves that we're making towards shadow banking and other forms of lending for home ownership, right? So one of the things that I think we need to hang our hats on is the regulations relating to safety and soundness that big banks are already governed by. It's just that we have to make sure that they remain governed by those rather than being able to spin off subsidiaries that can engage in all kinds of risky activities. So thank you for asking the question. You saved me from forgetting to say this myself. And that has to be a part of the regulatory picture. I mean, and I will say again that, in some respects, I fear that putting this on the table at this moment of understandable disaffection with banks just makes the whole thing seem completely, pie in the sky and unpragmatic. But I do want to start to talk about shifting that kind of reaction to a feeling of we really just can't afford to let the big banks go at this stage. And so we have to force more regulation, including certainly of that.
Laura, you should run it from here as to who asks next. Just raise your hand, you have to get Maura's attention.
And if you want to ask a question.
Hi. My question is, what resources can be developed to assist houseless people in getting affordable housing?
Sure. So the question is, what resources can be developed to help houseless people get housing? Did I hear it correctly? Yeah, I mean, it's become a almost like a glib statement to say that homelessness is a housing problem, but homelessness is a housing problem, right? Like we're short the one of the presidential candidates says 3 million units. I don't know what the national number is. Here in Connecticut, we're short about 140,000 units. There isn't enough supply. And it makes all of the problems you heard about from this panel, even though we weren't focused on the question of supply, it exacerbates every one of these problems, right? So our clients who live in substandard conditions who would prefer not to don't have a lot of choices. We have had clients in possession of a voucher who cannot find a unit to live in, who can't vacate a substandard unit because there's literally nowhere else for them to go. We've created this like crazy amount of landlord power on the backs of a housing shortage. And we are still, like, day in and day out, every single day here in the state of Connecticut, rejecting the production of new units that wouldn't require any subsidy whatsoever because of local zoning regulations. One reason I tussle with my own proposal to better regulate property management is that I've spent a lot of my career tussling against the overregulation of housing production. So I'm sort of keenly aware of the ways in which you can make housing too expensive without any commensurate benefits in terms of quality. And that's what we do. That's what we do right now. We've got a massive scarcity of units. So, as alluded to earlier, I can't remember which speaker, like the vast majority of low-income people who qualify for housing assistance don't get it. The number is something like 1 in 5 or 1 in 4 people eligible for housing assistance actually get it. So obviously, like, you need more subsidies as well, but we have taken a crisis that largely affected low-income people, and over the especially the last decade, but at least the last 50 years, we've put a lot of effort into actually making that problem worse and worse and worse and worse, to the point today where it also affects middle-income people. And that's a supply problem. So we've talked a little bit about, like, local activism and what you can do. Like, go to your local zoning hearings, tell them you actually want more housing in your communities, that you're not against the idea of 63 units a quarter mile from a train station in Fairfield County, because there are literally people on the other side who are day in and day out, like, literally think it's like a good use of their time to fight new housing. And maybe they should join a bowling league or something, but so long as they're doing that, the rest of us need to fight that fight as well.
I just want to comment on, policy priorities as well, and the recent Supreme Court decision of Grants Pass that further criminalizes homelessness. And I think it speaks to our country's priority of the prison industrial system, that how much does it cost to house someone as compared to put them in prison, and what is our priority? So some jurisdictions have a housing first program, which might be criticized and might have its benefits, which is housing people without the precondition of being substance free, or do you address other needs first before putting them in or finding permanent housing? And so some cities have that sort of program, which seems to be effective somewhat, but it just speaks to in those jurisdictions there tends to be more communication between law enforcement and then social service programs. So if somebody is arrested for trespassing, in other words, sleeping on the street or being outside in public places where they're not wanted, is law enforcement going to bring them to jail? Are they going to refer them to services? That's all I have to say.
All right, I just want to give our panelists a round of applause and thank you for your interest.
Thank you all again for attending today. We hope you leave with new insights, new understanding of how the roots of housing policies can help us tackle current challenges, AI's role in both housing access and discrimination, and how the engagement of marginalized voices and communities in general are vital in shaping effective housing policies that will benefit generations to come. Just a couple of things as we wrap up here. We, again, thank everybody who was involved in making this possible. We could have absolutely never done this by ourselves. Thank you to all of our panelists who came today. We appreciate all of you. And for those of you who are fair housing professors, some of our wonderful panelists, specifically Stacy and Professor Oliveri, are coming out with a casebook for you. I've been told that this has never existed before. So in February of 2025, keep your eyes peeled for the right to fair housing. And I look forward to hopefully seeing that in classrooms around the United States. And just really quickly, if you are not subscribed to the Connecticut Law Review and you would like to be, there is a QR code on the bottom of that piece of paper that's in the center of your table. You can scan it with your phone and sign up for the Connecticut Law Review there. And that will let you have access to our Symposium issue, which will have published works by almost all of our panelists today. So thank you all again.
I think I would just like to add that I encourage everyone to take today's insights back to their communities and continue advocating for equitable housing solutions. Thank you.